Well, good morning, everybody, and welcome to the most recent edition of The Box, a regular look at topical issues affecting those working in and around the insurance broking and intermediary sector. Presenting today myself, Neil Frankland. I am a partner in our professional indemnity team with a specialist interest in insurance brokers. And my colleague, Sam Morley, who's a senior associate, and again, who has a specific professional indemnity specialism and in particular deals with claims with brokers. As usual with our box series, we're going to speak for approximately 15 minutes. There'll be some time for questions at the end. Please feel free to submit them using the chat box as we go along, but we probably won't wait to answer them until we finish the main presentation. If we don't get to your question at this point, or you're watching this by the webinar and something comes up later, please do feel free to email us directly and we'll get back to you as soon as we can. So turning to what we're going to talk about today, we're going to talk about the demands and needs. Has the pandemic changed a broker's duty of care? We're going to look at the before. What was the duty of care pre-pandemic? The now, the impact of the test case, and the future. How might the duty on a broker to ascertain a client's needs and demands have changed going forward? So just a word to the current position, the current law. One of the key obligations that the broker owes is to ascertain the needs and demands of its client before it advises and recommends an insurance solution. It's a core duty and really sits at the heart of what the broker does. Without it, without knowing what it is the client wants and indeed needs, it can't sensibly perform its role. Although this is a core duty, how the broker is to meet it is not particularly well codified. Indeed, as is the case with many brokers' duties. The best guidance that there is probably comes from the Insurance Conduct of Business Sourcebook, the ICOBS, at 5.2, where it states the broker must, prior to the conclusion of a contract of insurance, specify, on the basis of the information obtained from the customer, the needs and demands of that customer. So effectively, it's an obligation to give a statement of the basis of the advice, a statement of the basis of the advice and recommendation is given on. And also the ICOBs go on to say that when proposing a contract of insurance, a firm must ensure it's consistent with the customer's insurance needs and demands. But little guidance is given beyond this as to how those needs and demands are to be identified. So, how is this to be determined? Well, either by experts or peers in the industry, giving evidence as the broker's conduct as to whether they've fallen below the standard or not that the expert considers would have been reasonable to expect. Or, as the court has indicated in the past, without expert evidence, without expert input, and with the court, effectively the judge, taking the view on this as a matter of factual interpretation and evidence and common sense as to whether or not the broker has gone far enough to examine and explore its client's needs and demands, such that it is not necessary to have an expert. More recently, events around the COVID pandemic have brought the broker's duty around needs and demands into sharper focus, particularly when looking at the FCA test case. Whilst that case was, of course, all around the obligation of certain insurers to respond or not to claims arising out of the pandemic, it's also led to consideration of the broker's position and whether the cover placed actually met the needs and demands as determined at the outset. So now I'm just going to pass over to Sam, who's going to briefly talk about business interruption on a slightly more general basis, but also to look at some of the current authorities or the as-was authorities in relation to a broker's duty. So Sam, over to you.
Thanks, Neil. So in terms of business interruption insurance itself, it can be an add-on to another insurance policy or a completely separate insurance policy. So business interruption insurance is intended to cover financial losses suffered as a direct result of a business interruption. So basically anything that prevents that business from operating at the same level in terms of revenue and costs. In the COVID-19 pandemic setting, this was key to businesses that were forced to close, also a reduction in revenue as a result of the government imposed restrictions. The most recent report from the Insurance Times details that insurers have paid out £968 million in interim and final business interruption insurance claims to date. Business interruption insurance is not necessarily straightforward, and care does need to be taken when taking out the policy, specifically in terms of the level of cover and policy that is obtained. The first case that I want to draw your attention to is the case of Arbor Group and West Craven Insurance Services. And this provides guidance to those of you who are brokers as to what a court expects from you in terms of duty of care. So in this case, the company in question was underinsured, and the court decided that it was because of the negligent advice given by the broker. As a result, the company was entitled to recover a shortfall in payments and damages for loss of profits from the broker. So as a result, it was decided that in these cases, the broker should have obtained cover for the company, which would have enabled it to recover its pre-incident level of profitability. The court also held that it was reasonably foreseeable that the broker's failure in doing so would cause adverse effect to the company. So the next case that we're going to briefly look at is the case of Jones versus Envirocom Limited. And in this case, looked at whether a broker could rely on standard form written explanations and warnings included in proposal and policy documents. And the court basically ruled that they couldn't. So again, for those of you who are brokers, it's not enough to include these warnings in template documents, but then not to give any further advice to your client. The last case we're going to look at is the Eurokey Recycling and Giles Insurance Brokers case. And this is a significant case in relation to business interruption insurance. So in this case, the court found that a broker is required to provide a sufficient explanation of what business interruption insurance is, how the sum of business interruption insurance cover is calculated, and what the indemnity period is. But it doesn't extend to include the broker being required to calculate the business interruption sum insured, but it is likely to include explaining key terms such as estimated gross profits and maximum indemnity period. Whilst those of you who are brokers are not required to perform a detailed investigation into your client's business, you do need to take reasonable steps to ascertain the nature of your client's business and insurance needs. So the nature and scope of a broker's obligation will also depend on the circumstances of the case, the client's sophistication, and the number of times the broker has met the client in the past. So for example, if you are a broker, you may not need to repeat the same advice every year if your client is an existing client, but this will be dependent on whether the personnel dealing with the insurance at your client has remained the same and that it can be evidence that such advice has previously been given. This case does also provide useful guidance to those of you who are brokers as to the standards required of them when advising clients on business interruption insurance. The decision is also said to try to seek a balance between placing reasonable limits on a broker's duty and the commercial reality that clients may not necessarily be familiar with concepts used within the insurance industry. I will now hand over to Neil, who is going to look at the impact the FCA test case has had on a broker's duty.
Thank you, Sam. Thank you. So the test case has raised a number of issues for the broker, none of which are necessarily new, but which are now brought into sharper focus. The fact that the broker needs to explain and advise to its client on the key terms of its policy is not a new concept. It's always needed to consider with its client the impact of the business seeking to trade or being interrupted and how and when the policy it is recommending will respond. Equally, there's nothing new in that when recommending a particular insurance product to meet a client's needs and demands, the broker should be considering the nature of its client's business. However, the broker is not, and indeed should not be expected to be a fortune teller. The broker is not expected to advise on all possible risks. Nothing else that would be wholly impractical and no doubt would lead to many more execution-only transactions, which would not be in the buyer of the insurance product's interest. How far the duty extends is going to depend on the facts of each individual case and the specific matters that are known or that ought to have been known by the broker, and subject to the overarching understanding of the typical types of risk that a business such as the particular client may face. That will extend to known risks, but it would seem very harsh to extend it to the unique and particular manner of events such as the COVID-19 pandemic, and where the response even of the government is very difficult to predict. So has the COVID pandemic led to more claims against insurance brokers? Well, in my experience, it certainly hasn't yet. In the initial stages of the pandemic, insurers began to turn down claims for BI based on COVID-related circumstances. Attention then briefly turned to the broker. However, it seems, and quite rightly in my view, that there was quickly a realization that the broker wasn't the fortune teller I've described. There has been, and continues to be, a recognition that what happened with COVID has affected everyone and was not simply something that was to be expected or predicted. Most commentators seem to accept, even those more used to acting for claimants in claims against brokers, that the circumstances of the pandemic are not likely to give rise to a significant number of successful claims against brokers. There has been an increased number of complaints, but that's not surprising. A good many businesses have suffered, brokers included, from the impact of the pandemic and have been left with nowhere else to turn. The Financial Ombudsman Service remains an option for unhappy insurers to make complaints about their insurer or their broker, but the swift action of the industry to obtain the test case decision has helped limit this. Further, the responses that we've seen to date from FOS, where complaints have been made against the broker, generally been supportive of the profession. They recognise that the pandemic has come completely unexpectedly and was outside anybody's expectations. And what's more, class actions against the broker would seem very difficult to get off the ground. Brokers act for individual clients, each with individual needs and demands. It's very different to the interpretation of a wording generally, which was effectively the FCA test case. And so each case is to be seen on its merits. Whilst it's possible that we're going to see some attempts at making out claims against brokers, properly analysed, it seems to me that they should be few and far between. The starting point, as we've explained earlier, is to explore the needs and demands. That's the duty that is owed. The broker, sensibly following on from what it does on all other aspects of a risk, though, ought not to be concerned. The allegation of breach to be made would look at a failure to identify a particular need for cover, not just for business interruption, because that's of course common to many businesses, but interruption arising as a result of the pandemic. Well, the last truly global pandemic was, I think, in around about 1918. The fact is that no individual business was expecting these events. The question of a total worldwide shutdown was simply not being asked by brokers generally, and nor did it need to be. The breach, if any, by the broker is by reference to not drilling down into any specific need or demand of a particular business that took it out of the ordinary, such that it might be said that specific cover ought to have been investigated. But then that's strained towards specific pandemic covers, which, whilst available, are expensive and were rarely purchased. A distinction needs to be drawn here around the failure of the broker to explain and advise on specific policy terms and conditions, the notification clause perhaps, or exclusions to the policy, and the absence of cover for the specific risk in the first place. If objectively that was not something in anyone's mind, it would seem harsh to now suggest that the broker is the insurer of last resort. The fact that some insurance policies to respond is down to their individual wording. It's what their contract of insurance says, and it's taken a Supreme Court decision to determine the point. Or some clients may ask, why aren't they on the wordings approved by the Supreme Court? That would be to ignore the huge number of other wordings that are present in the market, and which follow generally accepted market terms. It's perhaps more by chance than design that some insurers have ended up with cover, and that is to be determined without now having to reconsider their needs and demands at the outset. It is simply against what the policy says. So, to round up, the FCA test case ought not to significantly change the duty of care owed by the broker. That's the same as it's always been, to ascertain the client's needs and demands, and to obtain a policy that meets them. Going forward, society as a whole is likely to be very wary of pandemic-type claims. Whether we then see the insurance market start to offer up different products with different wordings remains to be seen. that starts to happen and cover for this sort of claim becomes more the norm, then in future pandemics, maybe the broker will become more exposed. But again, it's not necessary for the broker to predict all eventualities in the future. Complaints may increase as businesses face financial hardship with nowhere else to go, but that should not mean that they're properly analysed, those complaints are successful. Practically, the broker's practice is always going to change post-pandemic. They're likely to be more risk averse. That doesn't suggest that the good broker needs to be doing anything particularly different, and the same risk management messages prevail. Take time to know your client, properly consider the risk, and to ask open questions, and importantly, obtain a record of the advice given. So, one final point that we wanted to cover in our brief discussion today around the pandemic, and that's actually some internal risk management issues that the broker may face that are common to both your own practice and maybe those of your clients. So staff working from home, clearly communication lines have the potential to break down. The lack of supervision, which is key to many businesses, becomes stretched. By the same token, diary deadline management. Whilst there are central diary records in place, again, there is the potential, given people are more remote and not communicating in the same way, that deadlines get missed. Accessing records. Well, imagine the situation where the proposal or the risk register from 2 years previously is readily available, but the more current one is simply not because of IT issues. The broker relies on the older register, of course, with some the obvious consequences following of things being missed. Communication with clients. Again, a lot of what I've described is around communication, but it becomes stretched. Clients are not communicating with you in quite the same way. They're communicating at all hours of the day and in very different ways. And finally, responding to queries regarding to COVID-19. It takes up an enormous amount of management time. It's a necessary evil. It has to be done. It has to be done properly. And dealing with things properly would very much hopefully nip any potential claims in the bud. So that is the end of our presentation today. Hope you found it interesting. Hope it's given you some things to think about. Like I say, very happy to take a couple of questions now. And I'll go to my colleague Harriet in a moment. But if something that we don't cover in questions, please do feel free to email in. We're always very interested to engage and to consider these points further. So, Harriet, if you're there, perhaps have there any questions through in the chat box?
Yes, we do actually have a couple, Neil, which I'll just pose now, if I may. An interesting first one, given the extensive advice you've already given to the audience. But the question is that you've commented in some depth on the need to explore needs and demands and suggested some risk management areas for the broker. Is that it? Is there any other additional item that you'd like to add as perhaps a risk management tip or a best practice operation?
Yes, and thank you for the question. I suppose today we've started at the sort of the front end, haven't we? We've started today at the need to explore the needs and demands, and of course it's the core ICOB obligation. Having identified the needs and demands, the broker then goes and finds the policy, the policy that it will hopefully meet those needs and demands. And I think a concern that I have, having spoken to many insurance brokers over time, is when it comes actually to then examining whether in fact the specific policy terms and conditions meets those needs and demands. And I think, as odd as it may sound, that it is essential that when asked at a later date in cross-examination, you can turn around to the barrister or whoever's asking you the question, the judge, the client, that you've read the policy and that you fully understand and know the wording, the product that you've obtained for the client. I think developing that, but again, in part coming back to some of the points I talked about a moment ago, wordings in the market develop. They're developing all the time, aren't they? And I think we're particularly going to see wordings develop further now post-pandemic. And maybe a concern is that if a broker only trades with a narrow market and doesn't look around to wider markets, or indeed perhaps not have access to what the wider markets I think there may be a slight danger that needs and demands aren't necessarily being met because the broker itself hasn't got to the fuller cover that is available out there. Of course, there's wholesaling and various other approaches to market, and I don't want to get away from the primary message that you've got to explore the needs and demands at the outset. It's the starting point. I suppose the other obvious point that always comes on claims relating to BI and reinstatement values, etc., is the broker needs to be extremely careful not to advise on the amounts at risk. Now, very, very difficult because, of course, the client looks to the broker to tell it what those figures will be. It looks to the broker effectively to be its internal accountant, to be its internal surveyor. You need to be very, very careful around those points. And finally, record it. All too often, simply isn't the evidence around to support the defence of the broker's plan. So, yeah, I mean, we could talk all day about risk management for insurance brokers, and I'm very, very happy to do so. But yeah, those are some further points maybe I'll add as risk management. So I hope that answers the question.
Thank you, Neil. And interestingly, our next question perhaps takes the point a little bit further again. The question asks, when advising clients about gaps in cover, there are hundreds of possible covers available, and short of going around every single one, how can a broker protect itself against failing to discuss and explain the importance of extremely unusual risks and cover? One might say the short answer to that is pass it to somebody who can, but what's your view on it, Neil?
And that's so counterintuitive, isn't it? But no, I agree. I mean, I wonder if the question perhaps puts the cart before the horse. The starting point has got to be, keep repeating my mantra here a little bit, the starting point has got to be, what are the client's needs and demands? Identify those, then look to the covers that are available in the market. If there is cover available for that particular need and demand, can you quote it? Have you got access to a market that would quote it? If there is no cover that you're aware of, how do you communicate that back to the client? Do you say, I'm not aware of cover being available for this, but it might be available elsewhere, you should explore X, Y, Z? Or cover is available, but I can't get it for you, or I can't get it for you on sensible terms. It's an interesting point because there's a conflict arises for the insurance broker in part around this. And it arises day in, day out. And of course, it's dealt with the way you do risk registers and the way that you report back to the client in terms of the access to market and marketing your risk, etc. But I think just in answering the question as put, I think you're not advising clients about gaps in cover. Your starting point should be, well, what do you actually need? And then you can take it forward from there. Hopefully that answers the question. And again, I get the concern that possibly arises behind the question. And hopefully, as I mentioned, as I was speaking a moment ago, the broker is not to be the insurer of last resort. It absolutely shouldn't be. But I do get the concern that sometimes follows in the industry that is the way that things are perhaps heading. I would hope, from the comments I've made around the FCA test case and what we're seeing at present, that is not coming to pass, and that there's a realistic approach to certainly the COVID-related claim. So, look, I think that's probably all that we've got time for now. I just want to finally give a flag to the next edition of the box, which is to take place on Tuesday, the 19th of October at 11 a.m. And we're going for a slightly different approach on that next session. So we are going to be exploring MGA product development, and in particular, because they kindly agreed to join us, CFC's new transactional liability cover. And James Thompson, my colleague, is going to be joined by Angus Marshall of CFC to talk about how an MGA looks at developing. Look, thank you very much. There's on our website, there's all sorts of information about future events, and so I very much hope to be speaking with you, whether by webinar or in person, sometime soon. Thank you for coming on the webinar.